Wonderful. So you are joining us today for victims' rights litigation after Act 77 of 2022. We are very excited to join you today to spend just about 2.5 hours together talking about litigation practices and really trauma-informed litigation practices after Act 77 of 2022 and its clarification of standing in Pennsylvania. My name is Meg Garvin. She, her are my pronouns, and I am the executive director of the National Crime Victim Law Institute. And even though it's on the next slide, I'm going to ask Terry Campos to introduce herself now.
Sure. I'm Terry Campos, and I'm a member of the legal team here at NCVLI. I've been here for almost 15 years, and training, especially on litigation practice, is one of my favorite things to do. So I'm excited to be here and hope all of you have as much fun joining and participating.
And by way of some background, Terry is going to join on and off today, kind of as a color commentator in some way. She's going to join in chat and she's going to jump in and come on mic as she sees issues popping, I think. And the reason we're doing that is we want to demonstrate that litigation of victims' rights is an ongoing conversation, right? There is, in most instances, no right answer. There are right practices to brainstorm. And Terry has a background doing public defense work. And so that's an individual human rights litigation approach also, right? And so having her brain and her creative brain kind of pop in sometimes, even as I'm training, really helps us be as creative as possible. So I'm sharing all of that with you right now so that if you think, Terry just came on and jumped in the middle of Meg's sentence, right? We want you to know Terry and I have worked together for 15 years. So first of all, we are really comfortable with each other. But second, I welcome Terry's brain jumping in anytime because that's what makes for creative litigation and trainings. So you're going to see me mostly, but Terry will be in chat and then periodically come on as she hears things that she wants to prompt all of us. So who is the National Crime Victim Law Institute that Terry and I both work for? So NCVLI, we are a national nonprofit based in Portland, Oregon at Lewis and Clark Law School, where I'm also a faculty member there, and we teach a legal clinic around victims' rights practice. I see some folks are getting audio feedback right now. If you are an attendee today, you get to mute and unmute yourself. Everybody should be muted right now. We'll invite you to come off mute later. We work nationally to promote comprehensive and enforceable victims' rights. As I've shared on the last couple of days, comprehensive, right? Lots of rights so that survivors have the option to participate in various moments across the justice systems. And then enforceable, this is so that the survivor can be in the mix. They get to be an active participant in the system. And this is really where Act 77 comes into play, is it clarified that the victim can be in the mix. They can be an active participant in the system with standing. So we're going to focus a bit on that today. As Terry and I have already introduced ourselves, we have another team member from this week's series of trainings, Rebecca Cleal, who will not be joining us today, but many of you saw her over the last couple of days. And then NCVLI has an entire team of attorneys and advocates. So if you reach out to us for assistance, you might get any number of us from the team. So I just mentioned that there were prior trainings this week. So would love it if folks use the chat to just tell us, were you at yesterday's training, which was really the basics of motion practice? So how many of you were here yesterday for the basics of motion practice? Use the chat box. And this is the start of participation. Great. Oh, some of you were here both. Terrific. Okay. Okay, and some were here on Monday, but not yesterday. Great. Okay, terrific. This is great. So we build in some overlapping information for folks who haven't been in on the days that were really designed to be together. Yesterday and today kind of build off of each other. Oh, make sure folks are on mute if you don't mind. but you won't. So if you were on yesterday, you might hear some of the same things, but phrased slightly differently or contextualized slightly differently. But then we'll be doing additional information. If you weren't on yesterday, don't worry one bit about it. So we want to learn just a little bit more about you. So we're going to launch a couple of polls here. And so if we can have the first poll come up so we can really know a little bit more about what your profession that you're currently sitting in, what you do right now, which of these fits most with your current role. So if folks could fill in this poll. Great, I'm seeing answers coming in. So victims' rights attorney is one option, prosecutor, other government attorney, civil attorney, an attorney with a nonprofit, a victim advocate, other. If you select other, please put in chat what the other is so that we can all kind of learn what those are. Great, victim advocate. Terrific. I'm hoping that we can get everyone to do the response. This really helps us know who's in the space, and also helps us know, okay, we can dig in deeper in certain areas or we have to go a little lighter in certain areas. Great. So we have a pretty good mix here, not really a lot of victims' rights attorneys, folks who self-identify as that. We have a handful of prosecutors, government attorneys, a couple of civil attorneys, a couple of nonprofit attorneys, and then some advocates. So it's a pretty good mix. Full disclosure, I'm going to be spending a lot of time on the legal, kind of designed to help the lawyers know a little bit about how to litigate, whether they're a prosecutor or a victim attorney. And I'm going to use all of the attorneys in the mix as the hope to become a victim attorney. If any of the advocates in the space have a question about something that I raise and I use too legal of a term, go ahead and put it in chat and we'll try to make sure it gets translated timely for you. And I apologize in advance if I do that. Let's launch the second poll, which is also just trying to get at your experience with victim attorneys. So if we could launch our second poll, that would be wonderful. So have you ever worked as or with a victim's attorney? So you yourself, or if you are a prosecutor, probably, have you ever worked as or with a victim's attorney? And I know this won't, advocates, it would be you working with. Yes or no? Okay, so we are having almost a 75-25, 70-30 split, with the majority of you saying no so far. Okay, 65-35. Okay, so for the 34% now, 34%, we're going to launch the last poll. Rachel, would you mind putting in chat what ICC is for the rest of us, just to make sure we all know exactly what you're mentioning when you say ICC? For the 34% of you who said you had worked with a victim's attorney, can you choose the vocabulary that really explains what that experience was like? Was it empowering? Was it fine? Was it frustrating? Was it other? And if it was other, please put in chat what that was. And Rachel, thank you for filling in what ICC was: indirect criminal contempt on a protection order violation. Appreciate that. Okay, we have 3 people said, or 42% said empowering, 42% said it was fine, 14% said it was frustrating. Okay, so one of the things that we want to get at here is it will, over your careers, even after Act 77, even after we do training on trauma-informed lawyering, it will likely be all of these things all the time, right? Lawyers will be able to help empower survivors. And that's what we're going to talk about today. They will be able to do that. There will be times when they aren't doing a whole lot because victims' lawyers don't have an evidentiary burden in the criminal case. So it'll kind of be like, it's just fine that they were there. They were helping the victim, but I didn't see them doing a ton. You not seeing them doing a ton doesn't mean they're not doing a ton with the survivor. So I want to flag that. And then other times it's going to be frustrating because they're going to be advocating for rights that don't go exactly the way you want them to. Whether you're an advocate, a prosecutor, a judge, a defense attorney, The entire purpose of a victim having their own rights is that they get to say what they need to say, right, when they need to say it. So just know that our goal is not to get you all to answer this with empowering as the only answer. Our goal is to get you to know that at some point in time in Pennsylvania's future, victim attorneys in the mix doing rights enforcement work should become the normal. It should become the norm, where victims access lawyers to understand their rights under an attorney-client privilege. They decide what they need to do with them, and then the lawyer is just another player in the system, right? That it just becomes the norm. That's what the victims' rights movement is doing right now. Across the country, that's where we're moving. So thanks everyone for participating in those polls. We're going to have a bunch of chat opportunities, more poll opportunities, and in the second hour, some small group work potentially, depending on kind of how our timing goes and how active everyone can be. So what are we really trying to do today? As you saw from the description, we have a couple of things we're going to work through together today. We are going to work through identifying trauma-informed, that's a separate idea, legal strategies for representing victims as they assert and seek enforcement of their rights in trial and appellate courts. And it really should say criminal trial and appellate courts, right? Because victims' rights enforcement is really about moving the survivor back into criminal justice, criminal legal processes, right? So that's one thing we're going to do. And then we're going to articulate considerations for creating a trial court record for effective precedent-setting appellate review. I want to unpack that second one. We're going to look at trial court records, right? Well, not actual records. We're going to think about how do we create a record, with the idea being that we want to create precedent, right? Obviously, when you are individually representing a victim, everything we do is about that survivor. Everything, right? And so if they wanted us to take something up for further review, we do, right? As long as we have a legal basis. If they don't, we don't, right? So precedent setting doesn't always come into play in the moment of representing individual victim. But we as a victims' rights community, you, me, Terry, all of us, right? What we know about the law right now of victims' rights in Pennsylvania, but also nationally, is there's very little case law telling us what do these words on paper really mean. And so we have to litigate, right? Law becomes meaningful when we get appellate court decisions telling us what the words mean. So that's how we're going to approach the second part of this, right? Around creating a trial record. How could we create a trial record that allows us to really think through appellate review? And we'll do some scenarios. I will note for you that a lot of times when you see kind of learning objectives such as this or a roadmap for a session, you think that the training is going to go exactly in this order. What I want to share is the trauma-informed piece is kind of bookends. We're going to touch on it right at the beginning, but we're really going to come back to it at the end. Okay. So the real goal, just full transparency, the real goal of this from NCVLI's perspective is to get the lawyers on the line to take the leap and be ready to litigate victims' rights. If you're a prosecutor, to be ready to partner with a victims' rights lawyer in doing the work, and or depending on the case, to carry arguments forward yourself upon request of the victim. And for the advocates on the line to be ready to nudge the lawyers in your life, right? We all know, most of us know lawyers in our lives who aren't prosecutors, and nudge them to say, you'll take a case, right? You'll take a case on behalf of a victim to help them have this empowerment moment of victims' rights. And so I want to share concretely, what does this vision of taking the leap look like? And what are some possible outcomes before we dig in? So back in 2003, so we're going back a little bit, right? Well, really 2002 and 2003, the Federal Crime Victims' Rights Act was being drafted. And the Federal Crime Victims' Rights Act is 18 USC 3771 for the lawyers in the space. it looks similar to what you all have, but I want to give you just this little nugget of history and how it evolved, right? So throughout the 80s and 90s, the Congress had passed rights for victims, just like Pennsylvania had, right? But those rights were kind of languishing on the books. And there were attempts to amend the United States Constitution, in fact, right, to afford stronger rights for crime victims. But in 2003, those efforts to amend the United States Constitution were meeting up against resistance that said, won't a statute do just as much as a constitutional amendment? Does that sound familiar to anyone? Raise your hand if that reminds you a little bit of the debate that happened around Marsy's Law in Pennsylvania, right? So this is the debate you all had around Marsy's Law, which we know was struck down on procedural grounds, is a conversation that happens nationally, and it actually happened in Congress. And so in 2003, the federal government took an approach that you all did in many ways. They passed the Federal Crime Victims' Rights Act, which really consolidated where victims' rights exist in the code, and it added an enforcement provision. Now, as Terry mentioned, for those of you who were on yesterday, and Becca mentioned, there was already standing on victims' rights, even at the federal level, but it wasn't used very much because normatively, right, culturally, we weren't used to having victims. So Congress took the same step. They made it explicit. The victim's attorney can assert these rights in trial and appellate courts. It's essentially what the federal CVRA says. So that passes in 2004. And the question was, okay, will anything change? So this case that is on the screen, Kenna versus District Court, this is the first case in the United States that made its way up to an appellate court on the Federal Crime Victims' Rights Act. And it made it up because of a victims' rights lawyer, combined with the support of the U.S. Attorney's Office, even though they disagreed with what the victim's attorney was doing, and with an advocate being the one who prompted the survivor to talk to a lawyer when they realized their rights were being violated. In the case, I won't give a ton of details, although both Terry and I would happily talk about this case for a long time. Fundamentally, what the case was about was that Mr. Kenna, a victim of crime, it got to sentencing and he wanted to be heard. And the court had already read his victim impact statement from the prior co-defendant sentencing, had already read his input into the pre-sentence report, or the PSR, which I know you all have too. And the judge said, I don't need to hear from you at this co-defendant's sentencing. And Mr. Kenna was like, but I think I have a right to be heard. And the judge said no. And the advocate sitting next to Mr. Kenna said, you do have the right to be heard. Not giving legal advice, just saying, here it is, right? And when they went out in the hallway after sentencing, sentence was imposed, right? The court moved ahead. Mr. Kenna, speaking with that victim's advocate from the U.S. Attorney's Office, then asked the U.S. Attorney's Office what to be done. And that time, the AUSA was like, I don't know. They connected him with a victims' rights lawyer who took the case to the Ninth Circuit Court of Appeals, the appellate court, and the Ninth Circuit Court of Appeals said the quote that is on the screen. The criminal justice system has long functioned on the assumption that crime victims should behave like good Victorian children, seen but not heard. The Crime Victims' Rights Act sought to change this by making them independent participants. And the court went on and held that the sentencing that happened in violation of Mr. Kenna's right to be heard at sentencing had to be stricken. It was an unlawful sentencing proceeding. And ultimately, the sentencing was redone. And so this rendering of a courtroom on the right, where you see three, I know it's kind of small, three tables in the courtroom, this is the vision. Not during trial. There's not a third table, right? Generally speaking, a victim's rights attorney won't have a huge role during trial. Every now and then, Rape Shield, they might have to figure out something, right? Evidentiary moments in terms of objections. But generally speaking, through motion practice, victims' rights with an attorney in the mix can move the survivor back into the well of the court in order to articulate their own rights. That's it. So that's the vision. And now we're going to spend some time digging in. And again, happy today to have folks raise their hand for us to talk about things as we go along. I'm going to share a bunch of ideas as we go. And then we will just keep having participation in various ways, but please use the chat if you have a question that comes up along the way. So we're going to launch another poll, right? And then I'm going to ask folks to consider raising their hand and coming off mute. So here is the poll for everyone. Which of these ways of writing this, right, spelling or grammar, I probably should have said grammar in the poll, sorry, resonates with you? Victims' rights, victim rights, victims' rights, or all of them or none of them? Wonderful. I'm seeing a pretty big split. 20% are on the first one where it's a singular possessive rights. 37% are on the plural possessive. 3% are on the no possession rights. 35% of you are on all of them. So one thing I should note, and I should have done this in advance, and NCVLI fully realizes that using an English grammar moment to talk about this stuff is not as inclusive as it could be. We're doing it because law is written in this way. So for those of you where English or English grammar is not kind of a comfortable space, absolutely know that that exercise probably didn't capture your full thinking. And we'll have other opportunities for you to participate that do capture. So I'm wondering if anyone, feel free to put in chat the why, but I'm wondering if any of the folks who put victim apostrophe S rights would raise your hand to come off mute and share what you were thinking. And I think I'll be able to see your hands come up. This will be an adventure. I'm trying to make sure I can. Is anyone willing to raise your hand? Okay, Schwan, I may be saying the name wrong. Would you come off mute and share? It looks like Schwan Kilgus. Oh, Sean, I'm sorry, Sean, would you come off mute? There should be a little microphone button. I'm hoping that it's there for you all. I think we tried to activate it.
Is this it?
Yes, yes.
Okay, I'm so sorry. This is the first time I've done a training on Teams. So I was like, where's the button? There's a button. So the reason why I picked the singular possessive is because I think of victims as individuals, and it is that person's individual's rights. There might be multiple victims, but that specific individual has rights. And that was sort of where my mind went.
Awesome. Thank you for coming off of mute, Sean, and being the first one to do that. Okay, and now I want to ask someone who did the plural possessive. If you would raise your hand to come off mute and just share what was your thinking. There's no right answer here, so don't worry about it. If anyone who chose the plural possessive would raise their hand to come off mute. No one? Okay.
Oh, I can do it. This is Suzanne Estrella. I couldn't find the hand raise thing.
That's all right, Suzanne. Go ahead.
I put the plural because my office is most often advocating for the rights of all crime survivors. So we're normally doing it in a plural sense.
Awesome. Thank you. Thank you for just jumping in, even if you couldn't find the hand raise. And that's fine, everybody. We absolutely can do it that way because, yes, these platforms, they're always all different. But fundamentally, what we just heard were from just two folks, but all of you participated. At the core, the apostrophe matters. The apostrophe matters in victims' rights, right? If we don't have an apostrophe, we're probably talking generally about victims and about rights. If we have the apostrophe, we are either focused on this victim and their rights and what they need right now. That's the singular possessive. Or we're thinking about broader, the whole group of victims and how can we advocate for them and how can we create precedent, right? Generalized precedent for everyone. And I'm going to hint at that a little bit when we get to the appellate stuff, because that can be where amicus come in, right? Even if you're a victim's rights attorney or a prosecutor working on a singular case, how can we have amicus curiae, friend of the court, come in and help litigate too, so that we're thinking about the plural possessive? But either way, either space you're in, the apostrophe matters, because we need to be finding out, what does the human being in the mix want to do with their rights? Or what does the group of human beings want to do with their rights? As a lawyer for victims, I am most often in the singular possessive, right? And I need to find out from my client, what do they want, right? When I am NCVLI, we're the plural possessive, but we still need to hear from survivors. What do you want? Because in law in the United States, right, Western European tradition that has been left here in the United States and that we have built up says that individual rights practice in law requires client directive, right? So this is where victims' rights need to move to. The reason, right, that is the law reason. And from a trauma perspective, what we know is that when we empower, survivors thrive. Empowerment is one of the keys to moving survivors along the spectrum, right? From victim to survivor to thriver, right? If we want to use that continuum. And Dr. Judith Herman, if you haven't read Trauma and Recovery, we at NCVLI really encourage that. There's a handful of books, right? The Body Keeps the Score is one of them. Trauma and Recovery, there's a handful of books. I'm going to mention Trauma and Recovery, Dr. Judith Herman, several times, but this quote is absolutely phenomenal. This is research from quite a long time ago that still resonates, but she notes that the core experiences of psychological trauma are disempowerment and disconnection, right? Disempowerment of a person and disconnection from us, from the community, right? And therefore, if you invert it, we need to empower and do connections, right? So the apostrophe is a part of empowerment. We're going to get to the connections later when we really return to trauma informed, but we're going to sit with empowerment for a minute as we move into the litigation realm. The victim's lawyer piece really matters. And I should have made this a poll, but I didn't, right? So understanding roles really matters, right? The prosecutor's client is the state. A victim's rights attorney's client, that's the victim, right? So just using chat. Now I want to be really clear. We have a lot of prosecutors on the line. Prosecutors are fighting hard for victims, right? Most prosecutors I know, my personal friends, as well as the prosecutors I'm not friends with, they got into the work to help community, to help survivors, and they work incredibly hard. And their client is the state, right? It's not an either or. It is not something that when we acknowledge that the prosecutor's client is the state, that we are saying something negative. It is perhaps the most critical, or one of the most critical roles in law, is to have a great prosecutor. And NCVLI also believes there has to be a great defense attorney, right? Because we want to make sure that the human rights of the accused are upheld. And there's another human being, the victim, right? So we need a lawyer, because the realm of adjudication of harm is law in the United States right now. It's one of the realms of adjudication, right? And so the victim having their lawyer so they can have an attorney-client relationship can make a difference to empowerment. And so really concretely though, that's all theoretical, right? Okay, I get that. Is anyone willing to come off mute or just put in the chat, whatever you're comfortable with? What is one of the biggest so whats? So what that the prosecutor's client is the state, or so what that they are to the victim's lawyer? Like, what are the impacts on victims from this role differentiation? Again, not good or bad in the general sense, but what are the impacts on victims from this? Is anyone willing to raise their hand and come off mute, or just put it in chat? Brady disclosures. Absolutely. Do you want to come off mute, Deanna, and share any more about Brady disclosures?
No, but I will. I'm just giving you a hard time, Meg. Sure. That's one of the biggest things that we try to emphasize, I think, in our advocacy work, the difference between what community program domestic violence advocates and privilege looks like versus if a victim discloses something that's either related to their, safety or otherwise information that they want to keep safe, if it is in any way consequential to the case. I think the legal standard might be some terms of art in there, but the prosecutor has a legal obligation to turn that over to defense counsel, which in turn likely would have an obligation to pass that on to the defense's client, which could then be used to cause harm to the victim.
I did not plant that answer, but you said it brilliantly. And so thank you. I absolutely know that coming off of mute is one of those things that we're all like, oh no, but I really appreciate it. So thank you. And thank you because you just nailed it, right? Like one of the so what's is the Brady obligation. And I see in chat differing objectives. Absolutely, right? Differing objectives. The Brady obligation is one of these concrete moments, and prosecutors absolutely, we all know this. Advocates know it, prosecutors know it, defense attorneys know it. And right, the Brady versus Maryland case from 1963 set forth this standard that is when the prosecution has evidence that is favorable to the accused, right? And favorable doesn't mean it goes to innocence, it goes to not guiltiness, right? Which could then mean credibility issues. They have to turn it over. And this is, you all may disagree with Brady, but from a general perspective of NCBLI, Brady is a really good rule, right? Brady is a rule that says we should not have trial by surprise, that we need to ensure that defendants can defend themselves, right? It comes from, let's not have so much power in the state, right? Like it comes from a human rights perspective, right? It matters. So when the survivor shares something with the prosecution has to do a calculus of, gosh, is this potentially exculpatory? And they rightfully so turn a lot of things over. But the victim is sometimes just navigating thought processes, right? And so they don't want to, they're just, it's not exculpatory really concretely, it's potentially exculpatory as the standard. And so if the victim could just work through some of that stuff in a privileged context with a lawyer, right? That's how we start to empower. Then the survivor, I will say many of the survivors with whom we work and the lawyers that we work with who have clients, they end up giving information anyhow, but it's a choice. They understand that when they hand their phone to law enforcement and law enforcement dumps it, if they had an attorney-client relationship where they got to think through this, right? They either are like, oh, I want to only give a limited consent for a search, or I totally understand that when I turn over my phone, it's going to the defense, and I'm okay with that, right? Like they really do it with intention, and that's where empowerment comes from. What's on the slide is, right, Brady says anything in the possession or control of the state is subject to the Brady. And as you see on the line, system-based advocates, others acting on behalf of the government, law enforcement, those all fall under the umbrella. You see a squiggly line to community-based advocates because sometimes we structure things in a way that community-based advocates are semi-subsumed by prosecution. So we can certainly do technical assistance on how to ensure that doesn't happen. But victims' rights attorneys aren't. They have an attorney-client relationship. So this is one of the differences in the so what's. Okay, so then we're like, all right, well, great. So that's a so what of why you might want an attorney, but what's the so what of what do they actually do, right? So I'm going to also tell a story to give a concrete example, right? And I'm giving a concrete example from another jurisdiction because you all are going to build this in Pennsylvania, right? You have explicit standing now, and so you get to build forward. Right? So what did another jurisdiction do as it was evolving its law that you could choose strategically to model after, or you could go a new direction, right? But I'm going to give you this example of Oregon. So history in Oregon, here's the shocker. It's not different than yours, right? We always think that each state has grappled with the same things. We don't always know it. And we think our struggle is super unique. There's almost always in victims' rights a common thread. So in Oregon, we first passed constitutional amendments back in, Terry knows the exact date, I think, back in the 90s, we passed our first constitutional amendments. Terry can jump in or correct me in chat. And they were struck down as unconstitutional. What? Right? Same thing. Single subject, we had put too many things together. Oregon moved quickly. Terry says she'll find it. Her memory's not helping her out. But she will find it because Terry really dug into the history in Oregon at one point, which was phenomenal. We quickly then passed it again, right? We separated out. We didn't pass everything a second time, but we passed a lot of the same rights again. But we cleaned it up and we passed it in a way that would withstand constitutional scrutiny. In ours, however, we passed a constitutional amendment that had this line in it. I'm paraphrasing, but pretty darn close. Nothing in this section can be used to undo any ruling. Nothing in this section can be used to undo any ruling. All right, anyone use chat? What did that mean for victims? So we afforded them the right to be notified, present, heard, and then it said nothing in this section can be used to undo any ruling. Anyone in chat? What did that do? It meant we gave rights and took them all away with a pen. Because if it cannot undo any ruling, right, eliminated the power of the right. If we cannot undo a ruling, it means when a trial court judge gets something wrong, we're out of luck. Right? That's it. You can't change it. So you're done. So I could assert them, but I was left to the whims of every trial court judge. So basically, victims' rights in Oregon languished. Same as the federal story, same as Pennsylvania in many ways, same as many other states. In 2008, we modified our constitution to strike that language. We don't have affirmative standing in our constitution. We have implicit standing. We have some, it says we can get a remedy, so it's a little stronger than implicit, I should be clear. But we also then in 2009 passed a statute, and the statute is explicit on standing, but also how we file motion practice, right? So we went a step further than Act 77. We went and said, you file a motion, here's how you do it. We basically laid out a system that was originally intended to help pro se victims. I will say, and CVLI helped draft it. We failed horribly. If it was to help pro se, we need to fix it. Thank you, Terry, 1996. But in 2011, so in 2009, we amend the 2008, we amend the Constitution. 2009, we pass a statute that says, how could you assert the rights? And in 2010, with the decision issuing in 2011, we have our first case that goes to the Supreme Court in Oregon. And here's the way it played out and what a victim's attorney did. Again, a victim was not notified of a plea entry, a change of plea entry. At the change of plea entry hearing, it went straight to sentencing. So under our law, the rights of the victim that were violated were the right to be notified, the right to be present, and the right to be heard. The prosecutor's victim advocate didn't even know this was happening. When they found out, they had built a culture in that prosecutor's office of allowing advocates to point out errors, right? That's a cultural moment that we need in our prosecutor's office. The advocate said to the assistant district attorney, I think you might have violated the victim's rights because I never got to tell the victim about these proceedings because we thought it was a status hearing. And again, in a cultural moment, that DA's office had a culture where the ADA, the assistant district attorney, was empowered to tell the elected, I think I messed up, right? So this is culture. We need to get there. The ADA told the elected that, and the elected called NCVLI and said, we may have violated the victim's constitutional rights and statutory rights. We are going to try to remedy this, but we also know that the victim may not trust us, right? They absolutely understood trauma and trauma response. And they said, is there any way you can get the victim a lawyer? And we did a little like happy dance at the request, not at the rights violation. And we got the victim a lawyer. And what the lawyer did, so now we're starting to get practical. What the lawyer did, first, consult with the victim, right? Victims' Rights 101, Lawyering 101. What does this survivor want? Does this survivor want us to tilt at something in the legal system? Do they want an apology? Do they want an ethics complaint? Do they just want to be out? What do they want? And what remedies and rights could we activate to secure those remedies? So it was a consultation with the victim. And the victim was like, two things. One, this was a domestic violence stalking case. And the victim was like, oh my gosh, this person is out and I don't have any real notice of like what's happening, what their supervision is. I need safety. And I'm really angry I wasn't heard because I had some specific things to say. Right? Okay. So with that, the victim's attorney filed a motion for reconsideration and vacation of the sentence. Right? So it was resolved by plea agreement. They didn't tilt at the plea. They just, based on what the victim wanted, which was protection in the sentence and to be heard at sentencing, that's all they went after. Right? So the victim drove the remedy. At the trial court level, the trial court said, I see that a victim's right has been violated. I don't think I can do anything. I don't know what remedies exist, right? Because this was the first time. So the victim's attorney said to it's on the record, said to the trial court, thank you very much, Your Honor. We do intend to appeal this. And the trial court said, great, I think you should, right? This needs to be clarified. And would you draft a proposed order? So the victim's attorney got to do the first version of drafting the order. So for the non-lawyers in the room, right, what you often do is the court will ask the parties, right, and victims can be parties to that litigation moment. They're not parties to the underlying case, to draft orders, and then the court refines them, right? But normally it's prosecutor or the defense drafts it, but they reach agreement, they then submit it, the court finalizes it. Victim's attorney got to draft the order. When you get to draft the order the first time, you can be really precise, right? Now, it still has to be run by the prosecutor and the defense, but okay. Drafted the order of denying the victim's rights. That then was appealed to the Oregon Supreme Court through the devices available in Oregon. We'll get to your devices. And the Oregon Supreme Court said, yeah, victims' rights were violated. Resentencing is permissible as it does not violate double jeopardy. We're fine. That's what it can look like, right? That's what a victim's rights attorney can do. And if you listen to the story carefully, you heard the prosecutor was doing great work, right? They just goofed and it happens. And they had an understanding of trauma sufficiently and the limitations of their own role to say, we need partners here. And this victim needs their own lawyer, right? So let's move in it. The outcome from that case, let me be really clear here before I ask you for some thoughts. The outcome of that case is a couple of things. One, we actually haven't had to take up another sentencing rights violation since, with the exception of one where a judge literally told a victim to stop talking, and we won that one too. But generally speaking, our sentencing proceedings go well because the outcome of Barrett in practice, not only do we have a good precedent case, it resulted in a rule change. So after the Barrett case issued, the victims' rights community, the prosecutors and the defense all got together to propose rule change. And the rule change was, let's have a colloquy on the record at sentencing. A colloquy is just the judge asking questions. And that colloquy is there a victim in the room? If the victim is in the room, does the victim want to be heard before sentencing occurs? Great. If the victim is not in the room, they turn to the prosecutor because that's where our notice obligations are. Can you affirm on the record that you notified the victim of this proceeding and that they did not want to be here? If they cannot affirm it on the record, the sentence gets continued. The sentencing proceeding gets continued. That's the actual outcome of all this litigation. It is not a particular sentence, none of that. It's about ensuring that the survivor's in the process. Yeah.
Oh, okay, thank you.
Oh, I thought someone was coming off mute to ask a question. Okay, so I am going to ask you all now, okay, so what do you think of this? suspend your, I don't think that can happen here, unless it's a legal argument. But what do you think about this example, this process of involving victims' attorneys, the motion for reconsideration? Just use chat or raise your hand and come off mute. What do you think? Waiting to see if anyone types. It requires a drastic reduction in ego on the part of the prosecution and the judiciary. Suzanne, it looks like you might have come off mute. Yeah, go ahead.
I think it's doable. I mean, our office actually presently sits as the office where people can file complaints. So sometimes we actually have to interact with judges or whatever about various complaints. And for the most part, I mean, you do get some that they don't want to hear it. But we have many that are actually like, oh, geez, they didn't want to violate a right. They want to see what is the remedy and how we can make it work. I mean, we've even had judges call during a sentencing and saying, hey, there's a victim here and we don't know whether this person was properly notified. Is there anything your office can do to make sure that they're ready? So I think it will take a lot of this collaboration and communication and talking and really working to make sure that it's done consistently every time. But I think that it is doable, and that I'm going to say more often than not, I get the impression that people really do want to do it right. But I know that that's not often the case. And when it's not the case, it is usually really ugly. And that stinks too. So, but yeah.
Yeah, I appreciate. So some things someone else put it rests on the quality of the relationships between the attorneys and the judges. Fears that judges will proceed anyway. Did someone else want to come off mute and jump in? Okay, someone is off mute. I want to make sure you go back on mute so we don't inadvertently hear your conversation if you don't want to be off mute. So one of the things about the Barrett case, right, is even in Oregon, right, there were going to be some jurisdictions, some counties where this would have been horrible, right? There would have been judges who didn't, in the reconsideration, create a good record, right? Didn't allow us to be involved in that, right? So there's a dual approach that we recommend, right? One is building up enough lawyers in your space so that you always have referrals for victims, right? And that those referrals are not when a violation happens. We'll talk about that in a second. You're not just reactive, you're proactive to prevent violations, but also being really strategic and choosing good relationship spaces where you're like, we know violations will happen. The best of us violate victims' rights. NCVLI has misstepped, right? Even though this is all we do. I personally have misstepped, right? By saying the wrong thing on a line in a bad trauma-informed way where a survivor then didn't want to work with us and her right likely went away because she wasn't going to take my referrals either, right? We all misstep. And so what we want to strategically do is identify the spaces where we have a good enough platform that when we misstep, we can go to the appellate court and create precedent so that future missteps are less likely. You get the colloquy, right? So it's a combination of direct representation and really thinking forward. So I do want to flag this, right? The two examples I've given so far, Kenna and Barrett, so the federal case out of the Ninth Circuit and the Barrett case out of Oregon, both involved moments where the violation had already happened and we were seeking a remedy for the violation. That happens, it will always happen, and we don't want to just be reactive, right? It doesn't serve survivors for us to only be reactive. And I'm going to put pause on what's on the slide for a second and answer the question in the chat. Should you give the victim the option to file a complaint without discussing this with your DA or boss? So what is the best practice? So first of all, there should be a policy in every office about what to do when a right is violated. Every prosecutor's office and every judiciary should have this conversation and should really embrace violations will happen. There's no way around it. There's literally, we are human. And even if it was all technology related, like Vine, humans program it, right? There will be rights violations. So there has to be a conversation and a policy. And so our recommendation on best practice is that your district attorney's office develop policies around what happens when a right is violated. And that should include referrals to victims' attorneys, a complaint process, whether the district attorney's office themselves will seek reconsideration. It absolutely should all be in there. And we can do technical assistance on how to craft good policy around that. Okay, so going back to the slide, and I keep going over here because that's on my screen where the slide is we really want to be proactive, right? So victims' lawyers, what do they actually do, right? They actually do a lot of what lawyers do, talking, right? They need to be conferring with the prosecutor right away. Hey, I'm now representing the victim. I'd love to talk with you about the case. I'd like to understand what you see the current strengths are that you're allowed to share with me. Just have a conversation. We encourage victims' attorneys to have the same conversation with the defense. And a lot of people are like, what? No, right? But right, victims need to be in the mix, right? They need to understand what people are arguing and why, right? A recent case example where I actually undertook direct representation, and CVLI doesn't do that very often, but it was a sexual assault case, and it was moving forward in federal court. And when we actually had the conversations, right, the only thing the defendant cared about, right, actually was fine pleading guilty. There was going to be an admission, just didn't want to be on the sex offender registry for life. And the biggest thing there was the for life part. And the victim only cared about the sex offender registry while she was finishing school because it was going to live in the area and wanted to know exactly where he lived. That was it. And then there was resolution. But if I hadn't had the conversation with the defense attorney, we would have been under this assumption that it was totally against sex offender registry at all. They would have assumed that the victim wanted it for life. None of that was true, right? And the prosecutor was like, well, we want this charge. This is what we can prove. It ended up resolving, right? So victims should confer with the prosecutor, talk with the defense, should file a notice of appearance, right? And I know that was talked about a bit yesterday. File your notice of appearance. Let everyone formally know you're in the case. Keep the client involved in every resolution. So you're in conversations about plea agreements, right? Plea negotiations. Be involved in all timing, right? Make sure your client is specifically consulted on timing and disposition moments, and then be prepared to file pleadings, right? And so we are going to shift to filing proceedings, right? Or filing motions after the break. But what I want to flag for you is that NAVRA.org, which is a project of NCBLI, has sample motions, pleadings, memos in it. Now, you have to be an enhanced member, meaning it's a nominal fee, right, to do it. And so I understand that I'm pitching that, right? But I also want to flag this for you. NCBLI will do technical assistance for anyone, right? So you can always ask us and we'll help you write your motion. Absolutely will do that. That said, that you might be in a queue, right, to get our assistance because so many people ask. Just this week, and I checked right before this, we're up to 4 requests for assistance just out of these trainings, right? And this is just 3 of us doing trainings on 3 days. So if you want to access things yourself, we put our stuff in the database. So you or your organization could enroll and then get access. Pennsylvania specific motions right now in sample pleadings and amicus, I think we only have 6. But one is about remedies, pre-Act 77. It's in there. There's a memo analyzing how you would seek a remedy for a violation of a victim's notice right. Okay, so just putting that out there that you can look into that as we continue to all work together. We are going to take a break right now and then come back to digging in on some samples. So it is 56 right now. The minutes are 56. We're going to come back at 6 minutes after the hour. Okay, so 6 minutes after the hour, we'll come back and we'll jump in on the, okay, let's do it. Okay, see you in 6 minutes. Okay, welcome back, everyone. Hopefully you were able to stretch a little bit. We're going to stay as a big group during this time because I'm really grateful that all of you are participating as you can, which is great. So please keep that up during this time, and we'll take another break at about the same mark so that you'll get another break. Don't worry about that. So I want to just talk about, after talking about NAVRA for a second, I want to talk about, so as you're crafting your motions, and I know Terry, for those of you who were on yesterday, Terry covered this, but I just really want to think about remedies. So when a lawyer is working with a right? Okay, I have law that tells me I get to do something, right? I'm always analyzing, right? Am I affirmatively asserting it and saying, please protect this right? Or am I saying you already violated it, fix your violation, right? Those are the rights enforcement remedies. They're stop or do over. We're going to unpack those. There are, of course, other remedies, right? There's ethics complaints, there's civil liability. NCBLI is not going to talk about those on these trainings, and they're not our expertise. Ethics we can certainly talk about, but it's not our expertise, right? So when a survivor needs those moments, those are our remedies, right, along the way. Not civil liability for violating the rights, ethics for violating the rights, but those we'd refer you somewhere else. So as we're talking about remedies, we know there's far more than what we are going to cover and what we do cover, but we really want to stay narrow on rights enforcement in the criminal case. How do we increase survivors' opportunities for participation, including choosing not to participate, right? So it's not always about getting the victim in there and moving prosecution forward. It's what do they need? So if we're doing motion practice, right, and we're thinking about stop and do over remedies, we're crafting motions in those two spaces. We're crafting remedies in our motions for those. So at the end of a motion, for the non-lawyers in the room, right, at the end of any motion practice, you put in your request for relief, right? So you say, you argue, you're like, here are the facts, here's the law, here's what I want. That's called your request for relief. So when doing motion practice as a victims' rights lawyer, you're always looking at, and Becca and Terry covered the explicit standing provisions, right? Act 77 gives us that the victim has the right themselves through their lawyer or upon request the prosecuting attorney to assert their rights. Assertion is the motion practice, right? So some examples on the screen, right? Everyone keeps asking for continuances of the case. And the victim is like, why is this taking so long? Based on amalgamation of the rights, right? I don't have to find one that says a victim has a right to have trial happen on this date. What I have to find is that the victim, your policy statement above your rights, the little hat on your rights, is about the victim has a right to be treated with dignity. That's in your law. It might not be an explicit right, but it is policy statement. You have the rights to be informed. You have the rights to restitution. You can find different things. You put them together and you would file a motion saying, I oppose this continuance. I'd like a date certain for trial, right? The victim can do that. You do not, as a victim's rights attorney, have to find the exact right that says the exact thing you're looking for. You're looking at the whole body of law that was covered yesterday, right, by Terry, and you're putting it in there and then saying, the relief I want is a date certain, or a subpoena issues for the victim's materials, their Facebook page, their cell phone, their diary, their medical records, their education records. And you're like, well, the victim does have a right to privacy under both federal law, state law. You have some specific confidentiality provisions. You have privilege in Pennsylvania. You craft your motion and you move to quash the subpoena. Many of our first-year law students call it squashing the subpoena, and that works too. Quash it, stop, squash it, doesn't matter, right? Stop it, right? Protective orders over information. You affirmatively file for the protective order to secure information. Hey, I can't do something if I don't get access to that other information. I want it. Those are all proactive moments. And victims' rights attorneys in the ideal, in the gold standard, are representing victims routinely and simply doing this as a matter of course. oh, I see this happening, I need to file a motion, right? Like the same way prosecutors, as a matter of course, file certain pleadings, and defense attorneys, and then in the civil realm do it. Do-overs are when the right has already been violated. And then I'm asking for things like a reconsideration, a vacation to vacate something, clarification of the record, or appellate review, right? So I'm the youngest of 6 children, and one of my siblings is a lawyer. And when I first was telling him about what I do for a living 20 years ago, his response was, "So you're just being a lawyer?" And I'm like, "I am, right? I'm filing motions. I see a right. My client has a need. I ask for a remedy." It is not that unusual what victims' rights attorneys do. It's the cultural hurdles that Terry spoke about yesterday. And I'm sorry, I believe Becca actually spoke about them yesterday, that are the real barrier. So what we have to do again is normalize that the victim's attorney, we have Act 77 saying explicitly, can file things. They just start doing it proactively and then asking for reconsideration, right? Or do-overs. The 2 key places for victims' attorneys to be in, or among 2 of the key places, are charging and plea bargaining. So much of our justice system is resolved in these spaces. Victim status can be defined in or out of a case at the charging moment. Plea bargaining, absolutely, and entry of plea, absolutely either helps survivors or erases them. And so for those of you working in this space, if you're a victim's attorney, get in the mix early. If you are a prosecutor or a victim advocate, please know that trauma impacts from victims being excluded from these 2 spaces are massive for victims. So get them in the mix. It doesn't change how you as a prosecutor move your case forward, or it shouldn't. It's just another voice in the mix. So what are we going to do about precedent? So I'm shifting gears, right? So Terry spent a lot more time on motion practice yesterday. So now I want to shift us to how do we create precedent, which is also creating meaning in the rights, right? How do we do it? So going to talk through some fundamental pieces here that for some of the lawyers will be review, for some of the advocates will be review, and for some of both of those groups, right, will be new or reminders from a long time ago. So if you're mostly a trial court person, you often don't think about, so what does it take to get appellate review? And what do I want the record to look like to secure a really good decision? That's what we're going to talk about for a few minutes, because victims lawyers, this has to be what we do every day, right? It's both, I have to litigate now and I have to know what next year's litigation is going to be. So creating precedent, creating meaning. So some fundamentals. First fundamental, as a general proposition, and it is true in Pennsylvania, the general proposition is if an issue is not raised below, meaning raised in the trial court, presented to the trial court, it will not be considered on appellate review. Okay, right? That seems really basic, but what it means is I have to have thought through, as a prosecutor who's asserting on behalf of a victim or as a victim's rights attorney, what are all the things I might want to argue? This is why trial briefing is kind of often described as like throwing spaghetti against the wall, right? You're just trying to see what sticks. And as you move up the appellate courts, the briefing gets narrower, right? Because then you're seeing which things stuck and what you can really argue. This absolutely matters, though, that we need to be thinking, is it in the record? Did I get it in the record? Can I take a move to appellate review out of this? So we have to be thinking a year down the road, always, right? 6 months, a year, whatever. We have to be thinking about the appellate moment when I'm briefing something at the trial court. So some steps on this. And this series of slides is attributable to one of Terry's and my and Becca's colleagues, Amy Liu, in our office, who came up with this brilliant device to help us think about how to create the trial court record to help us preserve for appeal. So just use the chat for a second. If you can, what is the picture on the screen? Those of you that can see the picture and know what it is, what is the picture on the screen? because I'm going to try and get us really deeply to understand the way Amy taught us this. Okay, it's a kangaroo. So I'm not sure how many people. Great. A kangaroo with a joey, right? So it's a kangaroo mom and a baby. Okay, so in Winnie the Pooh, if any of you are Winnie the Pooh fans, what was the baby kanga called? The baby kangaroo called? Mom was called something and the baby was called something else. Roo! Oh my gosh, awesome. Okay, so creating the record, what we want you to always think about is the roo, the kangaroo, right? So you have the big moment, but you're always thinking about the what's in the pouch, and that is roo, okay? So this is how you go about thinking about creating a trial court record to create a good appellate moment. Roo, raise the issue, object timely, and obtain a ruling. Roo, okay? You need all three of these things to be constantly going through your mind, right? As a lawyer. Raise the issue, right? Because we know the general rules. If it wasn't raised, we don't get to argue it. Object timely if a right is violated. Yeah, Amy is brilliant. One of our colleagues is just brilliant. And then obtain the ruling. All right, I'm going to unpack each of these, right? Because there's a lot more to them, but really this, if you can remember this, we can together really work on building the records, okay? Okay, so raise the issue. This means you need to do motion practice, written or oral. We'll dig into that a little bit more in just a moment. Object timely. This means you need to be in court, right? Objections can happen on the papers or orally, it doesn't matter, but it means, right, for a victim's right to really move forward, we have to have that court appearance. We have to be like, we object to this violation, we object to the process the court is doing, right? And then obtain the ruling. Ideally, we get written rulings out of courts on victims' rights issues. It is incredibly challenging to litigate if it's not a written ruling. If you can't get a written ruling, we need to have you dig through the oral transcript, get those transcripts, see what's in there, see what did the court actually say, what did the defense attorney actually say, what did you actually say? Look at the transcript. It is utterly fascinating to see what you actually said. Invariably, when I rewatch trainings I've done, I did not say what I thought I said. It just happens. And I do rewatch my trainings to try and get better. It's important, right? But it's like, oh my gosh, why did I say that? That's not what I meant. And we're going to unpack what do you do then? Okay, so raise the issue, right? So you need to raise it in a way that's sufficient for the appellate moment, right? So that a court on appeal is like, oh yeah, that issue is clearly in the record. I can rule on this, right? That's the standard you're going for. You need to present it in writing. That's the gold standard, right? Raise issues in writing. Brief victims' rights issues. Reach out to NCBLI, we'll help you brief it, right? If it's raised for the first time during the hearing, right, things pop. They're always popping. Prosecutors, I'm amazed at your adeptness, right? For like issues are constantly flying at you. Try to have the argument ready in advance, like anticipate so that you can have a clear argument on the record, but also follow up in writing, like ask for additional briefing on the issue because a passing reference might not be sufficient, and then get the transcript. Okay, this is how you raise issues sufficiently, which often requires us to pre-brief things, right? What might come up in a hearing, and let's have our arguments ready to go. Let's brief as much as we can in advance, right? That is the R of RU. Object timely, right? We absolutely need to avoid waiver, right? So if victims' rights are being violated, right? We're having a hearing that the victim was supposed to be notified of, but they weren't, but we let the hearing go ahead. We could seek reconsideration, right? But that reconsideration is going to be better if we've objected in the moment and the court has said, I'm moving forward regardless, right? Because then we have an intentional moment. We have a violation of right that's much cleaner, right? So objecting timely and allowing a court to consider that objection is incredibly important. So we need to be watching for moments all along and giving courts the opportunity to fix it, right? Giving our courts, most of our courts try so hard to get the law right. And they too are human, and they too may not be as experienced as we want, or they might be too experienced, right? Time to leave the bench, but we need to give them time to remedy. And we need to be thinking about victims' rights at every proceeding. A lot of times in our practice, Terry and I observe that people are like, okay, I'm going to be ready for restitution at sentencing. Okay, just use chat for a second. When might you want to be thinking about restitution? Just put in chat. Do you wait till sentencing to be thinking about restitution? I'm waiting to see what comes in. Central court, discussion starts at prelim. Yes, from the start. You need to be gathering the records. Something can go from a charge to a plea to a sentencing very quickly, right? At the prelim. I love this. You all are brilliant. And we need to know then that the issue might pop at any moment, right? In the court, we might move to an agreement very quickly. We might inadvertently say something on the record, right, that implies no restitution if we haven't been thinking about this, right? So we need to be thinking about all the rights in advance, avoid saying things on the record that can be perceived as waiver, and then being ready at every proceeding for all of the rights to happen, right? It takes a lot, which is also why prosecutors are juggling the entire evidentiary case. This is also why having a victims' rights lawyer in the mix can be useful, right? Because prosecutors have to be thinking about the burdens, right, of proving a case. They're thinking about all the witnesses. They're thinking about putting together a strategic case. They're thinking about getting evidence admitted, right? All of that. A victims' rights lawyer is there to look for victims' rights issues. That's it, right? It's a totally luxurious job compared to some prosecutors' jobs. We know this, right? It is useful because you have to focus so that in the RU, you can object timely, right? So the O, the first O. The second O, obtain a ruling. We have to obtain rulings. Ideally, if you are filing a motion, like if you are proactively filing a written motion, submit it with a proposed order. Because if you have to craft, if a lawyer has to craft what order do they want the court to rule, first of all, you brief the issue better because you are more specific. Second, your oral argument will be better. If you have already thought of the order you want, and this is actually how we train our law students, first know what you want the court to say, then write your brief. What is the outcome you want, right? What is the order you want? Then draft your brief, then draft your oral argument, right? So ideally, victims, lawyers, prosecutors, if you're asserting the right, submit a written order that includes the order on the victim's right? Make sure the findings are there, right? If you're going to need any findings on appeal, make sure they are there. What did the court have to find? Did they have to first find that the person is a victim? And then rule on it so that the defense or someone who's challenging this later would have to challenge both the finding that the person is a victim and the substantive outcome? Probably. Do they have to find in restitution that the victim owned the car that was damaged? Maybe, right? Be thinking about what findings need to be in there and make sure those are either in the proposed order or on the record. Again, gold standard is a written decision. Second is the transcript, but get them both, read the transcript, and then file a motion seeking clarification of the record if you need to. This is a step that gets missed often, right? We think, oh, we can clean it up in our appellate briefing. No, we want to clean it up at the trial court level. So file a motion for clarification or reconsideration of a particular thing so that you have this really clean record. That's the second O of RU, obtain the ruling. Okay? All right. One thing to think about. Waiver happens in the weirdest ways, right? And it becomes moments for all of us as lawyers where we're like, oof, right? Like, oh no. And so I'm going to give you one example, right? One example of this is out of this U.S. versus Klein-Smith case. Now, NCVLI was the amicus in this, full transparency. We did not represent the victim, but were amicus in the case. And in this case, fundamental issue was, and I'm not going to go into all of the background of this case, happy to do that with anyone. It's a very complex case, but fundamentally, defendant pled guilty to one count of false statements. And the Dr. Page was one of the people who asked for victim status. So Dr. Page files a motion asking for victim status for sentencing and argues, I want to be heard at sentencing, or argues victims have the right to be heard at sentencing and to restitution. Okay, so files a motion about this. The court goes itself very carefully through the transcript and the motion practice that Dr. Page filed. And here is a quote, and I'm going to ask you all to listen carefully to the quote and then tell me what you think was waived or might have been waived. So Dr. Page files a motion saying, under the Federal Crime Victims' Rights Act, I want to be a victim. A victim is a person directly and proximately harmed by the commission of the offense. Okay, that's the definition. Both the defense and the government oppose this. And then the court goes through and finds this in the briefing. Quote, given the numerous, this is from Dr. Page, given the numerous difficulties in establishing the appropriate quantum of restitution, I am not seeking determination of the amount of restitution. I'm not asking for restitution at this, I'm not asking for a specific determination of the amount of restitution. What was waived? So he says, I'm a victim. I need to be heard at sentencing and get restitution. And then he says, given the difficulties in establishing the appropriate amount of restitution, I'm not asking for a specific amount of restitution. What did he waive? Anyone? Yes, restitution. Now, you might just be thinking, well, it's not a trick question, Sean, because you're like, well, it kind of is. You're kind of like, this seems so obvious he waived restitution, but let me unpack it and where the lawyer's brains should have been going, right? So one, the court is like, you're telling me you don't need me to figure out restitution, so I'm not going to do restitution. And therefore, because as a trial court, I have the inherent authority to hear from anyone at sentencing, which is true all across the country, I don't need to determine whether you were a victim or not. So Dr. Page was trying to help litigate the definition of victim. And by waiving his specific claim to restitution, or the court finding, the court also was able to duck his issue of whether he was a crime victim, because it exercised its discretion to hear from him without that finding. So for the advocates in the room, you might be thinking, what? Lawyers are just so messy with their words, right? Like, or they just care about the weirdest things. Isn't he a victim or isn't? Is he a victim or isn't he? But the lawyers in the room should be like, oh, the rights build on each other. What is the court's inherent authority versus its obligations only if there's a right? And in victim law, discretion is the bane of the existence of a victim's rights lawyer. Because if the court can do something by discretion, it's not going to rule on your issue, right? Does that make sense to folks? Okay, I heard someone come off mute and I just want to check. Okay, all right. So RU, right? Really be thinking about RU in order to set up appellate review. That's the most important thing when it comes to creating meeting, right? We have to create a clean record so we can then get to the appellate court and then set precedent. So you might be wondering why we talk about preparing for appellate review versus appeal. Is anyone willing to come off mute and share why, or put in chat, why you think we use appellate review, or that we have appellate review and appeal on the screen? Is anyone willing to come off mute or put in the chat? Okay. Keep putting in chat. I know sometimes it takes a little while. It is so important. As lawyers in law school, we often got taught two things. One, you can take an appeal, or two, you can petition for a writ of certiorari to the US Supreme Court. The world of appellate review is so much richer than that. So those of you who aren't lawyers, most of the time when we get to the US Supreme Court, it's what's called a petition for a writ of certiorari. That's this old vocabulary around a device you use in law to say, would you please take this case? Totally discretionary. Appeal is a creature of statute. It usually says right in statute, so-and-so, prosecution, defense, can take an appeal. So we often really talk about this as victims lawyers, as a victims' rights community, moving towards establishing precedent. We have to be thinking about appellate review, not just appeals, because those are narrow. What are all the devices we can use to get to an appellate court? And sometimes those are explicit. Sometimes we have to figure out how to leverage things. And so vocabulary absolutely matters. And I'm going to dig into writs in just a moment. In addition, you have to have standing. So just because the victim had standing to assert their right at the trial court doesn't necessarily mean they have standing to assert their rights still. So you have to redo the standing analysis that Becca and Terry shared, right? Injury, causation, redressability. That has to be present even with Act 77 on appeal, right? So you're looking like, or on appellate review. So you're like, okay, do I still have standing right now? Is this right still ripe? Has it become moot, right? Do I have standing? So you cannot forget that. You're then looking, do you have any statutes on appeal? Well, interestingly, you all have some appeal statutes that are pretty broad. It's not as narrow. Many jurisdictions, it's literally, it says the state can appeal. You actually have original jurisdiction in your highest court over a whole lot of cases that might give you avenues into appeal. And one of the things that we wanted to flag today is, as we don't practice in your jurisdiction, when it comes to the specific device you want to use, we would like to do technical assistance with you. So we want to have a local appellate lawyer, you and us, so that we can strategize, right? But you might have appeal in statute, right, that we might be able to leverage. There's good avenues to do that. We might be able to leverage your appeal statutes and create case law that says you get it. And appeal is great because there's not as much discretion. Appeal as of right is the court's going to have to review something, right? Ohio is an example of a jurisdiction that has victims' rights. In its constitution, actually said that you had to that you have to use a writ of mandamus, but it didn't say and no other avenues to appellate review exist. So a victims' rights attorney in Ohio filed both a writ and an appeal and said, whichever is right, could the court please consider it properly? And the court actually said, in case law now, the victim can appeal. You also have that writ of mandamus, but you also can appeal. So there's ways for us to litigate to create more and more avenues to get to the appellate court. And that's one of the goals. We need motion practice, but then we need to be able to get to the appellate court to create meaning. There's devices like the writ of certiorari that are discretionary review. Those are less strong than, I guess the better word is weaker, than an appeal as of right? Because the court can say, I don't want to take it. Extraordinary writs are another device. We want to go through all of these. The two that are cleanest in Pennsylvania, we have a lot of arguments for appeal. The two that are cleanest are what are known as a writ of mandamus and a writ of prohibition. You have those in statute. The device that you do, the way you brief them, is actually the same. The rules around writ of mandamus or writ of prohibition point up to the rules around writ of mandamus. Mandamus you use when someone has failed to do something they're legally obligated to, and you're asking the court to order them to do it. Prohibition is when someone is failing to do something they're legally obligated to do, and you're telling the court to do it, to tell them to do it. You have both. And you now have Act 77 that says you have appellate standing, right? Generally, you still have to establish it. So we have ways to get to the appellate court. So as long as you do the rue and you've created the record and obtained the ruling and objected timely, we can get to your appellate courts to create a Barrett, to create a Kenna, right? To create precedent that changes practice. And that's where the prosecutors and the victims' lawyers really need to be collaborating. And one of our recommendations is choose a couple of issues that you really want to focus on to move towards, right? Because that's where Barrett came from. We were like, sentencing keeps getting messed up. If we can create positive precedent in sentencing, we will do it. So when that case presented, we were all hands on deck. We got the victim a lawyer, NCVLI did an amicus, we consulted with the prosecution, we talked to the defense. I mean, we were all hands in to create useful precedent. The last piece I want to share on appellate is, if you failed to get something well argued in the trial court, do not lose hope. Like if you didn't get reconsideration, the judge fails to say, I'm going to fix this. Lots of times we can still get something in, right? We can do it under the court's original subject matter jurisdiction. It might be implicit in a different issue raised below. Or we might be able to argue that if the court doesn't consider it, it would be a miscarriage of justice. So gold standard practice is follow the rule, right? Have the kangaroo image in your mind and go through the ROO. If that didn't happen, or you tried and you were shot down, that's bad vocabulary. You tried and you were unable to succeed, we will still try to work on figuring out how we get the issue presented on appeal, okay? And this is why collaboration around this stuff absolutely matters, because sometimes you think you preserved it, but when Terry reads the record, she's going to be like, I don't see it in there. So we need to collaborate. Okay, we're going to do some practice. So you need to get involved. Now, everyone who's been multitasking, I respect that. And we need your opinions now. They're not going to be polls. We're just going to have you involved. Okay, so we're thinking strategically about advancing victims' rights. All right. All right. So here we go. This is about language choice. So I'm giving you hints. You are victim's counsel. So you're the victim's lawyer. You file a notice of appearance, okay, and a motion asserting rights. Great. Okay. You are filing around the right not to be excluded from a proceeding. Okay, pretty standard. Terry and Becca spoke about this yesterday too. You have an affirmative right not to be excluded. There's some standards in there, but you file this notice of appearance and assert the right not to be excluded. And the trial court strikes your filing for, quote, lack of standing. Okay, you're briefing the reconsideration in order to set up appellate review. What language do you use in your motion for reconsideration? Okay, so for the advocates on the line, you might be like, I'm not sure. That's okay. The lawyers aren't sure either, right? And there's not always a clean answer. It's getting us thinking about this. So what language do you use? The trial court erred and should grant the victim standing to file this motion. B, the trial court erred in failing to recognize the victim standing to file this motion. C, I don't know, and I want more information specifically I would want, and then put it in the chat. So everyone, using just the chat box, A, B, or C. Awesome, we have a lot of B's coming in. Would someone who has put in B, who has not yet had the chance to come off mute, we're going to start there. Would anyone who put B and hasn't had a chance to talk yet, who's willing to raise your hand so I can call on you, and you could just share what your thought process was about B. Is anyone willing to raise their virtual hand and come off mute? Everyone would love to hear a voice other than mine. Abigail?
Yeah, hi. I would put my request for what I want the court to do only in my order. I don't think you need to have it in your motion.
Awesome. And so you would put it in your order, and then do you see a difference between how you would put it in that's a great strategy, Abigail, and spot on. So your order has it in there, and then would you do a difference between A and B in your order? And if so, why?
I guess I would just put the victim is granted standing in this proceeding as like my language for the order.
Okay, awesome. Thank you. Thank you so much for coming off mute. I appreciate it. Anyone else want to jump in and share? Okay. Oh, go ahead, Charles.
So I picked B. The reason I would go with B over A largely is because I would include a direct quote from the statutory language in my motion.
Awesome. Say more. Go ahead.
No. That's the end.
Okay. Yeah. Right. So one of the differences, so strategizing between, is it in your motion? Is it just in your order? How do you craft them? Absolutely. You now have this statute, and quoting it to be like, come on, court, like, what's wrong with you? Absolutely. And I would add one additional thing, right? One of the differences between A and B is the vocabulary of grant versus recognize. As we're continuing to grow victims' rights in jurisdictions, trying to make sure that it's not a court granting something that the law has actually already afforded, and instead of recognizing it, can help you build forward precedent. This one's not a huge difference, but we put it in so that you're like, oh, right? As you're building positive precedent around victims' rights, making sure that it is the court saying the law affords it, I'm just recognizing it, can help put in place lots of building blocks. This one wouldn't be like, you don't lose too much, particularly since you have the explicit statute. Before the statute, I would have wanted for sure you to do B, right? Because you had implied standing through the injury causation redressability test. That said, if you're briefing standing, we would encourage you to brief it both under Act 77, and then also just say, and the victim would meet the standard standing test, because then you have both. And if the court, or if a legislature down the road ever decides to try to take away Act 77, you've built positive precedent around your original standing too. So that's just one strategic thing to think about in language choice. Okay, let's do another one. All right, you're nearing sentencing, okay? And you know you're the victim's attorney again, okay? Or you're the prosecutor asserting, nope, this one you have to be a victim's attorney. So prosecutors, take your hat off and try and be a victim's attorney for a second. You're nearing sentencing. You know a pre-sentence report has been prepared, and you have reason to believe that reviewing it will help ensure that your client's victim impact statement is impactful, right? Is a full, meaningful exercise of the right. You ask to see the pre-sentence report, but you're denied first by the drafter and then by the prosecution. So you are drafting a motion for access to the pre-sentence report. What do you ask for? So everyone take a moment and think about that, and put in chat what you might ask for. How might you think about it? And then if anyone is willing to come off mute, raise your hand, please. We're going to take a full 30 seconds to think about it. Okay, is anyone willing to put in chat or come off mute what you might ask for? Great, a motion to compel. So a motion to compel access to the PSR. Suzanne, would you ask for the whole pre-sentence report or portions of it? Do you know? Have thoughts?
Probably just ask for the whole thing.
Okay. Anyone else?
I think basing it on the victim's right to be informed of the sentencing.
Awesome, great. So finding the hook beyond a meaningful right to be heard, it would also be the information right. Terrific. So I want to share with you a case around this, right? This becomes, again, a strategy, right? Thinking about, right, again, singular possessive victims' rights and plural possessive victims' rights. So they get mixed together sometimes. So this case, there was a federal case involving this, right? Very similar rights to information and to right to be heard as you all have. So nothing that says the victim gets access to the pre-sentence report. There's nothing in federal law other than if you're a kiddo that says you get access, right? Child guardians ad litem that represent kiddos get access to pre-sentence reports federally. But federally, the law is just like yours around this issue. And in the case, the victim's rights attorney was doing exactly what Suzanne said, right? I want the whole thing because in order for my client's right to be heard, to be meaningful, I need to know what everyone else in the space knows. Okay? And that's what their client wanted. So it was really driving their representation. That's a singular possessive, right? NCVLI was like, oof, this could risk bad precedent because an appellate court, if this eventually goes up, could say, you don't get anything, right? And this was the first time a victim was seeking access to a pre-sentence report that we were aware of in a formal motion practice way. And so we partnered. This is where the amicus moment comes in because the victim's lawyer had to ask for that. That's what they believed they needed. That's what the client needed. And the amicus, even at a trial court level, can come in, right? And we came in and said that the court could, of course, review the PSR for confidential information that should not be disclosed to the victim or that the victim would have to be under a protective order. So we crafted the next position over from the victim's rights attorney, right? So that a court was presented with options of how to rule on this case to honor the victim's rights, the defendant's rights, and to create a test for how it might disclose the PSR, right? Now, what I'll share with you is the actual case that went up federally. Our amicus got lost by the court and they didn't review it and we got a horrible loss. But we used that same strategy at the state court level a couple of times and it has worked, where the court has now created a test by which it reviews what is and isn't confidential with regard to, for instance, the defendant's or now convicted person's medical mental health history, right? And doesn't disclose that to the victim without a super showing, right? So you want to be thinking about, again, from a precedent meaning setting, arguing on behalf of the victim, setting up the motion practice, but also thinking what's the test eventually going to be, right? And so that's that example. I want to do one more before we take a break, and I'm going to go to this one, which is change with the game or change the game, right? And so we're always trying to pivot, and so we've been trying to share with you, yes, do motion practice, yes, have the RU ready to go. This one is about, oh my gosh, the landscape can change at any moment, okay? So defendant has filed a motion arguing that the victim lacks standing to object to a motion for in-camera inspection of privileged and confidential records. You're like, here's Act 77, what is going on here, right? Like, you file it, but you lose because the court says something, maybe they say they're not a victim, or they say this isn't a clear right? The court gets it wrong despite the clarity of the standing statute, which will happen, okay? So you seek appellate review under the allowed device. Probably in your jurisdiction, this would be a writ of prohibition. Everyone briefs standing, And so you're super excited because you're like, what? Act 77 only passed in 2022. It's 2023. We're going to get an appellate decision on this. This is awesome, right? That's where you're thinking. And then prior to oral argument, the court orders supplemental briefing and asks, should the in-camera review be deemed a per se privacy violation? And you're like, oh, the court might actually go to standing. We might not get that huge victory. They might focus on privacy. So what does your brief look like? If you're thinking singular S, apostrophe S, and plural apostrophe S, what do you put before the court? And just for those of you who may not know, in-camera review means that a court looks at things themselves behind closed doors before deciding what gets turned over. So it's often perceived as this protective moment around privacy, like the subpoena issues, only the court will look at things before they get turned over. But fundamentally, someone's still looking at your counseling records, let's say, your education records, even though it's the court. So what did the prosecution say why they said, oh, that was back for the other one. I'm sorry. No, they didn't in that example, Suzanne. Anyone have ideas on what you're doing here? Do you change with the game? Do you change the game? What do you do? I will share, as people are thinking, this is a case right out of Wisconsin. And Terry, who's on the line, we both had this moment where we, as the plural possessive S, victims' rights people, right, amicus, we got so excited about the court supplemental briefing request because privacy is such a huge national issue. And so we were like, great, embrace this. Let's get a ruling on privacy. And the local practitioners who have standing like you all do, but it hasn't been litigated up very cleanly, we're like, oh my God, if the court rules on that, we haven't gotten anywhere on standing. We really don't want the court distracted. We want a brief that that's an irrelevant issue. And so when you're doing, and as a practitioner, right, obviously you're going to respond to the court's order, right? You're going to brief something, but the way you frame it matters. So do you brief it forward that, you know, here's the answer on the privacy issue, but the court could resolve this issue completely on standing? Or do you say privacy, absolutely, that precedent should be shot down regardless of whether you find standing or not? And deciding that matters. When you are singular possessive S, privacy probably matters more to your victim too, but maybe not. As a community, this is where collaboration comes in. Trying as a community to take Act 77, right, to take your newly explicit standing provision and start thinking about how do we create positive precedent? How do we point the court? The court wants to talk about privacy. Is that the area that most survivors would benefit from? Maybe we go with the court and change with the game and get them to give us a ruling on that. Is it that trial courts, despite the clarity of the law, keep striking down motion practice, right, and aren't finding standing for whatever reason? Then maybe you need to stay focused on standing. This will be something that has to be an ongoing conversation. You have to be talking to each other across the state about what's going on, what are trial courts doing, what are the outcomes of that? Because if you don't, you will have willy-nilly precedent created. And the example of that, sadly, is California. California passed Marsy's Law in 2008 and has no clarity on most of the rights and just a smattering of very odd Court of Appeals decisions. They have many courts of appeals because there isn't a lot of cohesion in the state to talk about how to litigate. And so they have a law that's been around for 14 years that rarely concretely helps victims and doesn't help all victims yet in the way it could. It does help. I don't want to act like it's never helped, but not in the way it could. So we put in some of these strategic thinking ones, mainly to encourage you to keep having conversations. Know the rule, do the motion practice, have the conversations. Okay, it is 5 minutes till the hour. We're going to come back at 5 minutes after the hour and turn back to, now how do you do this in a trauma-informed way? Okay, so come back at 5 minutes after the hour. All right, everyone, welcome back from break. So in our final piece of time together, we're going to turn back to where Judith Herman started us in many ways about connection and being trauma informed. In the slides, you're going to have a couple of additional scenarios that we didn't get to, and those will be ones that you could use in internal trainings if you want. So if you see two slides and the ones coming up that we didn't cover, it's because we're providing you with additional scenarios that you could work through, and we'll provide the details on them. So you'll see those in there because they could be really useful as you move forward. Before we turn totally to being trauma informed, all of this should be trauma informed. I do want to also share with you some thoughts from my dog who's barking, but some thoughts that Terry and I and the rest of the team collected from practitioners around the country who've been doing this for a while, we asked them, like, what would you share, right? Like, what, as someone in the trenches, mostly doing victim singular apostrophe S rights, what would you share with folks turning towards it? And so these are some of the lessons that they learned / relearned that they wanted to share. So the first one is, it's critical not to, quote, trust the process, which sounds very negative, but if you keep reading, you'll understand, or trust that our clients' rights will be respected. The only way we discovered the egregious violation of our clients' rights was to routinely check dockets in our cases. In this situation, we discovered the violation in a few days simply because of our practice of routinely checking the dockets. It was a reminder to be vigilant. This is a group that files notices of appearance. So they formally enter the case, but because it is still new practice in their jurisdiction, even though they've been doing the work for more than 5 years, funded to do the work for more than 5 years, they still aren't always noticed on filings and aren't noticed of every proceeding. So your notice of appearance, it gets you in the game, but not always. So being vigilant. So one of the practice tips is to just keep checking dockets, checking in what's going on. The second one, don't assume an issue is settled just because every other judge knows the law on the issue. So this was another practitioner who actually was about standing and filing notice of appearance. This is one of the clinics that has been litigating victims' rights for 20 plus years. So Arizona has had law in the books that is explicit standing for 20 plus years. And the lawyer had never been kicked out of court on standing and got kicked out of court on standing because they were in a new jurisdiction, a rural county, who just hadn't seen it before. So even as you move forward, you might have to take a step back to keep moving forward. Being creative with the title of your motion can help get less resistance. So this is a practice that came out of one of our the lawyer groups we work with in Washington, D.C., who talks a lot about, like, you know, if you file something that has a request for relief that is phrased really bigly and just big in the title, people are going to react to that. So you find titles for your captions of your pleadings that are really benign in some ways. They're like, victim has a right not to be excluded. Just say the victim is not going to be excluded from this proceeding. Keep it narrow, keep it focused. Be creative though too. So in the Kenna case I mentioned at the very beginning, when the case was proceeding and the court kept not ruling on the issue, we filed like this really nice motion for status of previously filed motions, right? Just trying to get in there. So being creative with your pleadings is really useful. And then another tip, development of this area of law is largely guided by participants that are not the victim, as they are more likely to be represented. And the point that these lawyers were making was get in the mix, because otherwise precedent will be set. The scope of what victims' rights mean will be set by mostly defendants in their ordinary appeal and sometimes by prosecutors. So if you want to create meaning around victims' rights, we really need the lawyers and the prosecutors doing the work. Okay, so we're going to launch a poll here. And I think it's poll 6. And it's just a question to you all, true or false. I think we can get this one launched. Being trauma informed is a core competency of lawyers, true or false? I should have phrased it, should be a core competency of lawyers. Not sure. So we have 68% of you saying true, 20% of you saying false, some of you saying 4% saying not sure. Now we're up to 79% saying true. Great. We can go ahead and close that. So from NCBLI's perspective, the answer is yes. It's yes from a handful of reasons. One, the ethics rules require us to be competent. To represent persons who have experienced trauma requires us to be trauma informed in order to be competent. So our ethics rules tell us that we should be. From an efficacy standpoint, like until I started understanding the brain science around trauma and threat, I think I was a bad lawyer because I simply wasn't understanding what was going on. So efficacy requires me to do it. Now, is it something that we all learn about? No. Is it something taught in law schools? It's starting. But for all of us out in practice and for the advocates on the line, advocates on the line, be patient as lawyers learn it. The lawyers on this line, my guess is you already know a lot of it, but teach your colleagues, right? We are not going to be able to cover being trauma informed in these strategies in any depth, but we felt obligated, both because it's in the description, but also because competency requires it, that as all of you are moving into this space, that we touch on it. So there is no single definition of trauma-informed care out there. There are definitions out from the Substance Abuse and Mental Health Services Administration, right, SAMHSA, as well as Trauma-Informed Oregon have provided little nuggets of how to start to remember what it means to be trauma-informed. So Trauma-Informed Oregon is to remember about have an awareness of the prevalence of trauma in our communities, to understand the impact of trauma on physical, emotional, and mental health, as well as on behaviors and engagement in services, and 3, to understand that services can re-traumatize persons. Okay, those are pretty straightforward, and there are ways to remember it. Even more fundamentally, I think, trauma-informed, at least from NCBLI's perspective, means to allow the science of threat to guide our work. Once we understand the science of threat, we understand that second piece, the impacts on physical, emotional, and mental health, as well as behaviors, and we can base our work on the science. So take time to go learn the science of the brain and understand the science of threat, because it can help us become better at doing our work, whether we're a prosecutor, a defense attorney, an advocate, or a victim attorney, particularly victims attorneys, because you're going to be working with persons who your entire job is to help them be empowered, exercise choice, and if they're experiencing the ramifications of trauma and threat in the moment, that's going to be really challenging. So I want folks to use the chat box. If we're going to talk about being trauma-informed, we're going to talk about the science of threat and trauma. We'd love to hear what your definitions are. So if everyone could type one definition of what trauma is from your perspective, how do you define trauma? Let's get everyone to put in a definition. I'll start reading some of these as others keep typing. Lasting, how the body responds to stimuli that remind them of a negative experience or series of experience, a situation that never goes away, has lasting effects. The internal response to a traumatic event can vary depending on the person. Negative experience with emotional impacts. Fantastic, right? Having and understanding yourself of what trauma is a starting point. And we all need to have it. We need to have conversations about it so that we can decide how to have a trauma-informed practice around victims' rights. One definition that it can be useful because it broadens it for, at least for NCVLI's brain, my brain. It's taken from Dr. Chris Wilson of Being Trauma Informed, is that trauma, right, or threat, because they can be the same thing, is extreme threat, terror, and or horror, plus loss or perceived loss of control, right? All of the things that you put in chat, spot on. And this starts to explain why something is traumatic. So if it is an extreme threat to you, terrorizing, a horrific thing, and you have a loss of control or perceived loss of control, you are likely going to experience it as traumatic. If you actually have control, you likely won't experience as traumatic. If you have control, but you perceive you don't, you'll still experience as traumatic, right? It becomes very important because we can start to understand why a survivor in the criminal justice system might experience a traumatic moment, right? Both there's the being triggered, right? But there's also this moment can be horrific. I'm about to be cross-examined by my pro se offender and I have no control. Oh my gosh. That's not me remembering my trauma. That's not me re-experiencing that trauma. This is horrific right now, right? It could be a both and, right? And in fact, victims' rights can return that control. We can object. We can ask for standby counsel. We can return control so that that moment in the criminal justice system is less traumatic, right? So it's understanding all of these moments. And there's so many types of trauma, right? There's the acute, there's the chronic, there's the complex, intergenerational. If we're going to become good at this work, we need to understand all of them and understand the intersection of all of them. Again, we can't cover that today, but we need to understand it if we keep doing this. So as you keep doing this work, reach out, we'll partner, we'll find you the right trainer to do those trainings. But fundamentally, as we do the work, we need to understand that the brain's response to threat, whether it is threat to my physical body or threat to my status as a human being, as a good mother, as a good friend, as a daughter, right? It doesn't matter. The brain perceives threat to either of those the same and will have the same defense or survival cascade kick in: fight, flight, freeze, right? Flee or defend, however you want to articulate it. So being trauma informed means I need to understand how trauma affects someone when it was a physical threat, but also I need to understand that threat to status can have the same impacts. So if I'm going through a case where it's a sexual assault and a domestic violence and they're a married couple, and this is all about to come out, right? And maybe the kiddo of this couple might be removed, right? The victim in that scenario not only experienced sexual assault and domestic violence, but now is experiencing a threat to their status as a good mom or a good parent. And so they're going to have trauma reactions to that too. And so being trauma informed requires us to recognize that we and the system we're in can cause trauma, even when we're the helper. Oh gosh, I put up a slide that I should have flagged in advance. Some of you may be scared of spiders. The next slide has a spider on it. Sorry about that. My mother would be horrified that I put that up right away without disclosing because she hates spiders. So there's this idea in law, right? And our courts operate this way, and some non-trauma informed lawyers do too, that they simply don't understand that, right, that you were scared, right, in the incident, but oh, look, now there's no spider. Right? The court is like, there's no spider. Why are you having a trauma reaction? Why are you doing these things? Right? But it is Dr. Stephen Porges in his polyvagal theory absolutely explains this so brilliantly. And we as trauma-informed service providers need to understand it. Safety is the treatment, right? We need to make people safe. But safety, true safety, isn't simply removing the threat, right? So I'm going to go backwards. Your brain, if you are scared of spiders, if you encountered this spider, this size differential spider, and you're terrified because there's nothing you can do, right? And then I'm like, oh, I got rid of the spider. You are not safe yet. Your brain is like, I'm not safe, right? Because the removal of the threat does not make you safe. Our job in being trauma informed is to empower and connect, right? And so we have to get back to the apostrophe. A trauma-informed lawyer is that I know this spider is still there and I'm going to try and return, or at least it is in your thinking, you're operating in the world as if it is. I need to return to you power. I need to return to you a way to exercise control so that you do not experience this moment as traumatic. And that's where victims' rights can help. If we map to threat that we're part of the system that's threatening, survivors won't engage with us even as a service provider. If we map to being this super cute, safe space, right, survivors will know we're there to empower them and we can help them. And we as practitioners, whether you're a prosecutor or a victim's attorney, it doesn't matter. Every single space we interact with a victim, we have to be doing a handful of things. One, how do we be trauma informed? At intake, at client meetings, all of that. How do I think about threat and control, right? And making sure I'm empowering and connecting with the victim while I'm also doing RU, motion practice, and setting up an appeal, right? This is also why victim lawyers in the mix can be really beneficial, because the prosecutor, again, has other things they have to do. We can be doing both the RU and being trauma informed deeply. And again, from a competency standpoint, really believe we need to do this. If we do it right, we get the Kenna outcome. We get a prosecution office that violated a right, but apologized, moved forward, helped the victim. We changed the law, we changed the federal court system, and we have better off victims. Not perfect, but we have better off. And so this quote from Yoda, I don't even know if it's a real quote, but it's one I love. I'm not a Star Wars, like I can't quote the movie, but right, difficult to see, always in motion is the future. If no mistake you made, losing you are. A different game you should play. So I wanted to end with this and open it up to questions, because victims' rights practice, as we've noted for 3 days, you had standing for a long time. Nobody was activating it though. And now you've coalesced around a really clear statute. And now you get to go in court, right, in a different way. And you get to try to help survivors. You get to try to establish precedent. You get to try to elevate rights, both with the singular possessive S and the plural possessive S, so that today's victim and tomorrow's victim in Pennsylvania is better off. And that's hard work. And you'll make mistakes along the way, or you probably aren't pushing the envelope. If you don't ever hear no, if you don't ever get rejected by a court, you likely haven't pushed the envelope for victims. And our job is to be there with you. And so we're happy to do technical assistance along the way. And so we only have, I think, 6 minutes left, but I did want to see if there were any conversations or curiosities about anything I shared or Terry shared yesterday, or that just popped in your brain that you want to talk about. So you can put them in chat. You could raise your virtual hand and I'll call on you. I will keep looking at chat for a minute. I want to remind folks who were on yesterday, but also share with the rest of you. Feel free to put anything in chat still. That you can find resources. I've already mentioned NAVRA, but also on NCVLI's general website, ncvli.org, which is where you would ask for technical assistance. So please reach out on any legal issues that you think we could be of assistance on. And then also, if this is an area you're moving into, we would love to have you at our conference. So NCVLI brings together victims' rights practitioners from across the country in June, and next year it'll be June 5th through 7th here in Portland, Oregon. The RFP is absolutely open right now. So if you want to do a presentation, woo, that would be fantastic. So please submit a presentation proposal. Maybe you want to submit one about how you're thinking about moving forward on standing under Act 77. That would be brilliant for the rest of the country that still hasn't followed you yet to do that. So consider submitting a proposal to present, even if you haven't done this piece yet, but you're thinking about it. And we hope to see you there. Question in the chat, which I think might be designed more for others than for me, but I'll chime in on some things. So with this new act, are we likely to see connected funding to expand this kind of representation? I cannot speak to Pennsylvania. Maybe someone on the line can. I will say at the federal level, there often are grants that support funding for victims' rights enforcement work out of both the Office on Violence Against Women and the Office on Victims of Crime. So those would be things to look for. Several jurisdictions have opened their VOCA dollars to allow for some of crime victim compensation to go to lawyer fees, reduced lawyer fees for those lawyers who are trained and who have helped with rights enforcement. So it can't be for any lawyer. So those are some ideas out of other jurisdictions. And then also legal aid, civil legal aid, by their governing statutes is now authorized to do rights enforcement work. Whether they have funding to do it's another question. So those are some ideas on funding. All right, I don't see any other questions. Okay, on behalf of all of us at the National Crime Victim Law Institute, thank you. Thank you for passing the law, and those of you who were involved in it, because it really will help survivors. Thank you for participating over the last couple of days, and thank you for being partners in this work as we move forward. And again, reach out if you need anything. Thanks, everyone.
And Meg, I put the link to our RFP for our conference in the chat box.
Oh, brilliant, Terry, thank you.
And why don't you remind them about evaluations that they will be seeing today, hopefully.
Awesome. So check your email. You will get evaluation for each of the 3 days so that you can evaluate the entire thing if you were there or just the day you were on. Thanks, Terry, so much.
Mm-hmm.
Bye, everyone.
Okay, should just be us.
Great. I will send you, Jeff, the PowerPoint later today.
Okay.
And Terry, are you able to work with Julie or do you need help with the eval?
I already forwarded along the evaluations. Would you like me to? Yes, but I didn't draft an email to go with them. Would you like me to draft an email to go with them, or are you okay with just sending the link?
I'll put a quick note to it. Just asking them to complete the day or days that they were on.
Great.
Awesome.
Awesome. Well, thank you for giving us this opportunity.
No, thank you.
Yeah.
I think it was tremendous.
Yeah.
And I'm glad that people have been so responsive and already asked for TA.
One came in while we were at the break, Terry. I don't know if you, I think it went to all of us. It came in, another one came in today.
That's great.
I checked the email on the break and I was like, oh my goodness. I think it was, I don't know if it was from someone today or yesterday, but it's great. It'll be really good to partner on these.
Yeah. And funding is an issue, you know. I don't know whether you heard, but New York, I saw they had to like cut their funding to the civil legal programs because of the